Mike Harris, Director of Public Policy for Gun Owners Action League, and I am joined by
Kerrie Ann, Advocacy Director and Women's Program Assistant.
Also for Gun Owners Action League.
Oh, yes.
But no, we're here today to talk a little bit about the anatomy of a lawsuit. Just to give you my qualifications, I'm not a lawyer, but I did go to law school. I wanted to do this kind of work instead, so
I'm glad you did.
I didn't go for my license. Yeah, we're here. We're going to be talking about the Theodore case. It's Theodore et al. V. Campbell. And what that is our licensing case that we have filed against the state. So we sued for declaratory and injunctive relief. And that is in the United States District Court for the District of Massachusetts, the Eastern Division. We're going to have this up on the screen as well for you during this, so you can see kind of what we're talking about and what the parts of the pleading are.
Right.
Yeah.
This is all new to me because my whole job is to advocate. So when I first started GOAL a couple of years ago, this was like a whole different language for me.
So a lawyer's job is also to advocate, which is funny. So, but no, it's just a different kind of deal. So, what this is the initial pleading. This is called the complaint, and what it is the case laid out in pieces. It's kind of the initial story of what the case is, who the parties are in the case, who's the plaintiff, who's the defendant, what happened, and kind of just a walkthrough of the case itself.
Right. So like the anatomy of everything.
Yep. So it's kind of the case in chief. So each paragraph is numbered. You'll see there's an introduction, and then you'll see all the numbers, and then there's jurisdiction and venue. That's talking about where the case is being tried and why it's being tried there. The parties, so the plaintiff.
And how do they get the parties? Like, how does that all, like, if somebody's in, like, when we get ready to do a case from start to finish?
So what we do is we will find a plaintiff, and what that. The plaintiff has to be somebody who will have standing before the court, and we have to be able to show that. So they have actual damages. They're affected by the case. They're a member of they're a citizen of the place.
They're an outstanding citizen. They're not.
They're a citizen of the place where they're suing from. Okay. The internal vetting stuff aside, just being a plaintiff just means that you can show cause for damages.
I gotcha.
And that you've been aggrieved by, the defendant's action. So the plaintiff is the first name on the title of the case. So Theodore, in this case, is the first defendant, or the first plaintiff, my apologies. So it would be called Theodore et al., so the rest of the list, versus, so that's the V, Andrea Campbell, who is the Attorney General. So we're not suing her personally, we're suing her in her official capacity as Attorney General of Massachusetts.
Right.
So, being the Chief Law Enforcement Officer of the Commonwealth, she's who we sue. So, so there's the parties. It kind of just lists where they live, who they are, and then, then it will go on to show the statement of facts. So that's just the basics of the case. This is what happened. So
that's
in
kind
this
of the
case,
meat and potatoes of.
Yeah, it's kind of like the backstory of the case. It just says, hey, this is what happened, and this is what we're being aggrieved by, and so you'll see that goes on for a few paragraphs here, and it's broken up into sections because we're suing on
section of the bill.
Well, different portions of the bill, right? Like the first section, if you go back a little bit, it says, here's the general statement of facts, and then we'll say general requirements for a firearms identification card. And then the second section is the new general requirements for a license to carry.
Right. And I see it, obviously it has the actual statutes on there and explains
so you'll always
the new
put
law,
that stuff
the
in
old
there.
law.
No, kind of, Yep. So it just explains kind of what the differences are and why they have aggrieved the plaintiffs. And then, the unavailable safety training requirement, which is kind of the crux of the issue, that the new curriculum is not available. So, we're not going to talk about the meat and potatoes of this actual case, just kind of
we'll be here for another 2 hours.
Yeah. So this continues for a few minutes here. Discretionary suitability. That's another one. We have a few cases in Massachusetts backing that one up as well. The FID card and LTC licensing regime.
Does that mean that there's someone else that's also
we
being
have
affected
had,
by this?
So we've had 5 different jurisdictions. This is kind of a side note. We've had 5 jurisdictions within state court system, which is the municipal level, that have declared suitability unconstitutional.
Okay.
Just, in general.
So it could have been
the new standard and the old
anybody.
standard. Yep.
Okay.
But this is just calling that into question as a portion of the LTC requirements.
So it's kind of backing up.
It's just saying,
everything.
hey, this is another portion of the requirements that's not okay.
Yeah, not okay. This is not okay.
And just for the record, we'll have links to all of these documents in the link on the video. They're up on our website. They're public filings. You can find them by the case number up here if you also need to do that.
So case number
that's
and
up here.
docket number. Is that
It's the same thing, yeah.
Okay.
Basically the same thing. For the purposes of this conversation, it's basically the same thing. And it just refers to usually it's the court that it's being filed, and then kind of there's an identification number, and then then it's a civil case. So this is the ID number of the court. This is and then it's on the civil docket,
CV,
and
civil.
then this is the number of the case.
Of the case.
So,
Okay.
yeah.
There's a lot.
There's a ton
this.
to this. That's why you have to go to school.
Yeah, and that's why I have you, because being new at this, I look at this and I feel like I'm reading a different language.
Well, it kind of is. It's one of those. They've made it that way, like through the years. It's kind of silly, honestly. But
so I'm sorry. Yep.
So moving on. So now that we're past the statement of facts and the let me see. Yeah, that was still the statement of facts. Yep. So now we're moving on past that now. So this is the claims for relief. So this is the most important part of a
case.
of a complaint.
Oh,
is the
okay.
statement of claim, because if you fail to state a claim, the judge will toss your case.
That's it.
Without any review. Like they'll read through and they say, oh, well, you failed to state a claim. And there's a lot to that. It doesn't just mean like you didn't say we're looking for this or this is what happened. It's also circumstantial. So based upon the fact of whether or not your clients have standing, or your plaintiffs have standing, I should say, or if the case is ripe, which means that it's timely, or if it's moot or not, you could fail to state a claim on those types of grounds. So there's that. So those are divided. So claims are divided into counts. Usually, you can kind of do it your own way a lot. Most lawyers have their own style, but I like this way. So count 1 is violation of the 2nd and 14th Amendments.
Okay, I get it.
And then it lists out the reasons why that's the case. And then there's violation of the 5th and 14th Amendments. So void for, and that's vagueness. So that, and then that's the reasoning is listed out for that. And then your prayer for relief or relief sought, or whatever you want to call it. Like I said, lawyers all have their own style. And I like Jay Porter's writing. So
every lawyer can word it differently as long as it's in the same. It's
they're all terms
the same
of
format.
They're all terms of art. Like they're all kind of like just terms of art. That's the best way to describe it. And you can there are a number of different accepted like terms for it. So it's it's really neither here nor there. But when you get to this is the other important part. This is the relief that you're seeking from the court. This is what you're asking the court to do.
Okay.
So in our case, we are looking for injunctive relief, which is non-monetary. So there's 2 types of relief that you can get from a civil case.
Okay.
Nobody's going to prison, nobody's going to jail. You're seeking either monetary damages to be made whole, or restitution, something like that.
I know what it means, but for somebody that doesn't understand what monetary means, obviously they're seeking money.
Yeah, you're looking for money. You're looking to be made whole financially.
Okay.
But in this case, we're looking for injunctive relief, which is we're asking the court to do something other than financial.
Okay.
We're looking for the court to to declare unconstitutional some portion of the state's new firearms laws. Yeah, that would be great.
The whole thing?
But we're looking for the state to say, oh, well, this part of because of the 5th, 14th, 2nd amendments, these portions of the new firearm law in Massachusetts are unconstitutional. That's what we're looking for them to do. So we're saying, enter a temporary restraining order and preliminary injunction, which is a preliminary injunction is something that will be put in place while the case is being heard.
Oh, so it stops some of the bill at that point.
So it stops
the law.
Right. So it renders the statute unenforceable for
how many
those
months,
plaintiffs, but it's only for those plaintiffs, unless otherwise stated by a judge, which is
so it wouldn't be
often,
for anybody. It's just for the people that
just for those people. So so we're looking for so barring the defendants from enforcing the LTC regime unless its adequate infrastructure is implemented. So that's a little more broad. They're seeking for a general preliminary injunction, which courts aren't really keen to grant most of the time. But I can't speak for the Massachusetts, federal district court. It remains to be seen what they say. And then, we're seeking declaratory judgment that the LTC licensing regime is unconstitutional in whole or its constituent parts.
So how long, because I think the questions I get is, they don't understand really how long this takes to even draw this up. Because this is, I'm looking at it right now, we're buzzing by this, in 10 minutes talking about it. How long does it take in the background to get this ready?
So you can see the date up here that it was filed. So the law was passed in July. Yep. And then, it wasn't enacted until October, technically. But, we filed this pretty much immediately. So the process goes, we have to take a look at it, see if there's a way to challenge this. Then we have to find plaintiffs that fit
the needs,
what we're looking for.
Right.
And that's not always the case. Usually in a case like this, plaintiffs will approach attorneys and say, I want to do this. And the attorney will say yes or no. But technically we're a plaintiff on this case, but we're an organizational plaintiff. It's a little bit different. We are only a plaintiff based upon the potential fact that other plaintiffs that are members of our organization have standing on their own.
So we're kind of standing up for them.
Yeah, we're just
helping them.
So we're a plaintiff based upon the inverse of the deep pockets.
I gotcha.
Standard. So so ordinarily you would have a plaintiff that approached an attorney to do a case.
Okay.
But this time we approached an attorney to say, hey, we want to do this.
Some help.
We need to find plaintiffs to do this. So we had to look for plaintiffs. We had to find them. We had to vet them. We had to make sure that they were, properly aggrieved by this situation, and then that they.
The last thing you want is having a plaintiff on here, and you find out that there's some skeletons in the
not
closet.
Even that. It's
kind of thing?
Well, I always say this: most people aren't getting involved in the court system if there's nothing going on with them.
That's true.
So you're not going to find a perfect plaintiff to do this kind of stuff.
So let me ask you this: if you have, I see that the plaintiff's up top, and sometimes I've seen it where it's reversed. So what does that mean?
So you'll never see this reversed.
Okay.
So the plaintiffs are the ones who are bringing the case. The defendants are the ones who are responding to the case.
Maybe I've seen it.
So what you will see is on appeal, the names reverse.
Oh.
So whenever this is
seen or
whenever this is heard or decided, whoever appeals this will then be the appellant, and then the defendant will be the respondent. So it doesn't have to flip.
Okay.
If we lose, then we're going to appeal it, and so we'll be the appellant, and they'll be the respondent, and it'll stay the same order.
Okay.
But
so what if somebody decides to do this on their own? What's the term? Because I've seen that a couple months ago, and I'm like, what is this?
If you decide not to hire an attorney, it's called being pro se.
Pro se.
And it means you represent yourself. And it's kind of a crazy thing to do.
Yeah.
It's especially in terms of in terms of these kinds of things where they affect everybody's rights, I'm not going to say it's an irresponsible thing to do because it's not really my place to say that.
Right.
But we're working with a very
knowledgeable,
a very experienced, knowledgeable, incredibly intelligent
attorney,
constitutional attorney who handles these kinds of
another
cases as their bread and butter.
Because not every attorney can do everything.
No, you have to be barred in certain jurisdictions. You also need to be. So we have a local attorney, which is Campbell, Conroy, and O'Neill, that are filing this for us.
Okay.
And they are essentially vouching for our other two attorneys who work for Bradley Arant Bolton Cummings LLP, who are out of Alabama. They're entering them into the Massachusetts bar on a temporary basis, which is called pro hoc vice.
Okay, so because these guys are not necessarily Massachusetts attorneys,
they're not Massachusetts attorneys.
They
they're not
have
barred
to get a Massachusetts attorney to do it for
to
them.
file this case.
I gotcha. Okay.
And then in order to be officially made officially attorneys of record on this case, they have to be entered into the state bar on a temporary basis, and that's called pro hoc vice. So Campbell will say, hey, these guys are going to be working with us. We'd like to enter them, and the judge will say yes or no.
Well, that makes sense.
So,
I mean, breaking it down like you did makes it a little less confusing for me because I look at it and I'm like,
it's a lot.
And I put it away and I walk away. I'm like, he's dealing with it. I'm not. But
there's a lot to it.
I think the more you start understanding the process, then you can start understanding and appreciating all the hard work, money that goes into it. So going back to not only the hard work, now let's talk about the money aspect of this.
Let's just say it's expensive. I don't think we should get into specifics, but
Right.
it's
That's what I'm saying.
expensive to do this. I mean, there's filing fees, there's court fees, there's fees
All
for
over the
pretty
place.
much everything.
Yeah, because they're like sometimes $300.
And we're paying that.
Sometimes.
But on top of this firm, we're also paying this firm to be involved as well. So there's a lot, and especially when you're bringing a federal case, that could potentially make its way up to the Supreme Court.
So when it does go to the Supreme Court, I heard that if they look at this, they can decide, and all the money, time, effort, energy, blood, sweat, and tears. When it gets to that level, they can possibly say no.
Yep. So that's the Supreme Court granting review or not is called granting a writ of certiorari. It's a stupid Latin word that is really
hard to say.
Dumb to say. Certiorari. And they have the discretion to say yes or no what they're going to hear. I mean, there's thousands of cases that are making their way through the federal court.
True.
The federal court
and
system
it's not just
every
us.
year.
Right.
It's not just us, and it's not just these types of constitutional questions either. And they like to be specific with the case they take. Jurisprudence on the Supreme Court level is very narrow.
So that's why it's really important that if you're going to get to this level, that you have the people that know exactly what to do
and you have to
when it gets to that level.
And you have to find the cases with the best facts as well, because that's the most important thing. Like, bad facts make bad law.
Right.
So
where do we stand at this point?
So we filed this on August 1st, and the defendant, in this case the Attorney General, had I believe 90 days to file a response, or a response of any kind. And this is what we received on, I believe it was November 26th. This was filed,
and that's
this
what we received
is
from the state.
So this is what the state filed.
Okay.
They sent this they served this to us, via the means necessary under Rule. Oh boy, it's Rule 4 under the federal law. And now it has a civil action number. It's not just a case number anymore. So this is the actual docket number. So what this is the defendant's motion to dismiss the complaint for declaratory and injunctive relief. So this is kind of the defendant's first bite at the apple to get rid of this case. Obviously they want to win, and it's easier to win if you don't have to play. So what this is it's just a off the bat kind of swing at our claim. This says, hey, their claim is invalid for these reasons. They failed to state a claim. They don't have standing. It's all the administrative stuff that
they're looking at to try to.
And every defendant gets a chance to do this, and they all do, and it makes sense. It's the best way to go about it. So, once again, there's the title. It kind of lists out who everyone is in the case, and then it kind of goes through and responds to all of our claims in this and our requests for relief. So it's kind of a point-by-point argument against our arguments.
So then we can take this and then we can send them something back?
Yeah, so we'll respond to this.
Okay.
And then whatever judge is assigned to this case will take both the complaint and this motion and kind of
look at
them and then decide what they're going to do. And he can do this in parts. He can dismiss the whole case. He or she can dismiss certain portions of the claim, different parts of it. So,
oh wow.
And then on top of that, this is what's called a memorandum in support. So this is a gigantic document. These were kind of fun to write in law school. But this is all the research that goes into this. So everything in this is backed up by this.
Oh, so they give you that, and then they
Yep.
back it up with this document.
Yes.
So
Yep.
then you have to read through this.
So this is a memorandum. Yeah. So this is a memo of law.
Okay.
In support of their motion. So
my
what this does, and they have tables of contents and everything, and they kind of
wow.
walk through piece by piece, and the judge can use this as a backup document for this. So this is just a general, this is what we're looking for. This is what they're saying is wrong, and this is why.
Okay.
So it's just another thing. It's all built up, so it will mirror our complaint. And there's lots of footnotes, but this will basically mirror our complaint, and it will kind of walk through and attempt to tear apart our arguments as best as they can.
So
and that's
then
just the job of an attorney.
We have a right to repeal or rebut or comment back or
so we'll if the judge asks us questions, we can submit a supplemental complaint and an amended complaint if we need to with a certain amount of time.
This was recent? Oh yeah.
This was last week, November 26th.
Yeah,
yep.
Okay.
And that's kind of where we stand right now. We're just kind of
So can we
waiting.
look at this and then I guess comment back to them, say, well, we hear what you're saying here, but we feel this.
Well, we have to wait for the judge to kind of
look at this.
Look at it, and then we can file an amended complaint if we need to.
I see.
I'm a little Civ Pro is not my best class in in law school, so I'm a little rusty on this stuff. I haven't had to do it. I'm knocking the rust off.
Do they have so many days to get back to us, the judge?
No, they can kind of take their time.
Oof.
They're supposed to. I don't know it off the top of my head, but it should be a timely manner. You're entitled to a speedy trial, all that stuff.
So this isn't just absolutely blows my mind because I don't think people realize, even though the law dropped on July 29th, we filed this August 1st. So we were pretty quick with this. We got things rolling quickly. And I just don't, I think this is important, this conversation, because it's going to give everyone the understanding of how much work, time, effort, and energy, and how long it takes.
And if you go through this and you look at the citations, there's a ton. This is not us. This is the Attorney General. So technically, I guess it's us. Our tax money went toward writing this. But it's extensive. The research into this is insane. You're almost every line has a footnote. And every claim has a citation.
So these are footnotes, and this is just their meat and potatoes of what they're pretty much coming back at.
This is page 16. That's footnote number 14. So
I see.
There's a lot to these. So Tim Casey and Aaron Fowler are the assistant AGs that wrote this.
I gotcha.
And
Wow.
there's a lot to it. There's a ton to this. So after this, it's just kind of, it's back and forth between the judge, and then if they determine it's appropriate, we'll go to oral arguments, and that's when you're in court and you can kind of expound upon
Now,
your
if
claim.
this did get to that point, is it open to the public at that point, or is it still so anybody can go in,
Yeah.
witness it?
there has to be enough seats, but yeah.
Yeah.
Yeah. I think the district court is in the Joe Moakley courthouse. I know the First Circuit is, but yeah.
That's a lot. But no, thanks for just kind of going
No, of
through
course,
this.
I hope I didn't get.
with us,
I hope I didn't
because-
get anything wrong, because I don't have a lot of the time limits and stuff off the top of my head. But I don't know. That's not.
But
That stuff's not really important
I
at this
think
point.
if anybody's watching this, they're just going to be appreciative of just you breaking it down, because honestly, just this in general, and then the first part of it, it's a lot.
I mean, honestly, if you do read this and you forgive all of the citations and everything, it's actually pretty plainly written. I have to give them credit. This is a well done memo. I kind of enjoyed reading it. But I think they're all wet. I think they're wrong. I think we do have standing.
Oh, yeah. Me
They're
too.
challenging our standing and they're saying that because we lack standing and because of the 18-month delay that they've put on this, these requirements, that we are failing to state a claim, but I don't agree with that.
No,
But
because it's going to happen in 18 months regardless,
Yeah.
and we're going to be right back to
Yep.
the same spot we're at before.
yeah, and that's why, actually, that's another thing that I should kind of address in this. So what they're doing is they are, let's see, the final line on this is that they are seeking to dismiss our claim with prejudice. And so what that means is,
yes.
so with prejudice just means that we could not bring this again.
Oh,
So it's double jeopardy for the defendant. So this would be so if they dismissed it without prejudice, we'd be able to bring this case again in 10 months or
okay.
so. Whenever
So
when
if
this
they
is
say
done.
with
Yeah.
prejudice, then we couldn't.
Yep.
And so without means we can.
Yep.
Okay.
Yes, they can dismiss the case, and then once it becomes ripe, so they say, we would then be able to bring it,
And
properly.
we have all this information. I know we have a really nice section on our website.
Yeah, well, this should be up today. I made sure Jim had it.
Okay.
This should be up today with just a short little blurb about it. I didn't really want to go into a ton of details because, like I said, it actually kind of reads pretty plainly. Not a ton of big legal terms in it,
Yeah.
cognizable, but stuff like that. But other than that, it actually kind of reads pretty plain, and I think most people who.
So is there a list or something that somebody that is not like yourself, who's went to school for this, can print out so they can understand the terms better?
I mean, there's if you can find like a civil procedure cheat sheet or something like that. I used.
This you still have
this
to
one's
kind of
okay.
understand what you're doing.
Yeah, I mean there are some that are good, but like I said, I mean this one
Yeah.
I used to use this site in law school. It's called Cheatography, which is not the best title of a website that you're using for stuff, but it's not really cheating unless you're using it during a test or something. But it's not a bad.
But
it's not a
it
bad
really
little sheet.
is, good to kind of understand a little bit more of what you're reading, because
Yeah, I
if
mean,
you
like
can't
the rule
understand the
motions.
basics, this is going to be hard for anybody to read, right?
Yeah, I mean there's a lot.
Yeah. So we have been working it, and you've been working really hard, and we're very appreciative to the individuals that are helping us out.
Very.
And
We have
so,
a really, really good team of attorneys that are working on this
thank
with us.
God.
They're
Yep,
awesome.
thank God.
And
And we get a lot of members that are
Yeah.
supporting us and backing us up and
huge.
supporting the fundraising efforts for these.
because it's incredibly expensive.
We won't go
It's
into what it is.
prohibitively expensive. Yeah,
Yeah.
we're not going to talk about any numbers, like
So-
actual numbers, but lawyers make a lot of money. I don't know where we left off. We got cut off, but
yeah,
but
no,
we have
so
we have a
there's-
really good team of attorneys that are working with us on
Right.
this, and like we said, good attorneys are worth their money.
Well, I mean,
they're
they got to
expensive,
know their stuff, and they got to know their
great.
stuff all over the place. So,
And these guys, Jay Porter and Campbell, are fantastic.
Right.
So, and then we have other really good attorneys that we're working with across the state on other matters too, like Bill Smith, of course,
good. I was
Jason
gonna ask you that.
Gaida.
So this isn't just the only thing we're
No,
working
we
on.
have. Oh my God, we have so many in the hopper right now. Bill Smith is working on some suitability stuff. Jason Gaida is working on a whole bunch of different stuff, including suitability. I don't know how he does it. He's stretched so thin. And Dan Hagan is just a beast. He's gotten 4 different jurisdictions across the Commonwealth to declare suitability unconstitutional, like I said a few minutes ago, including Boston Municipal Court. So he is an absolute beast.
That's awesome.
Hats off to Dan Hagan. He's a monster.
And you know what? Thank God and thank you for everything you've done and are
those
doing.
guys are great.
Because it's a lot, and I appreciate you. And I know we have a lot of supporters, and we have a lot of members that are supporting us, and so I appreciate that.
So, but one of our things here at Goal that we've been trying to do is just not be so much a gatekeeper with the legal stuff, is just be more of an air traffic controller. We have a lot of national groups like the NRA and FPC, Second Amendment Foundation, NSSF, that all want to be involved, and we have a lot of attorneys and we have a lot of plaintiffs across the state that want to be involved as well. And we got the coalition; those guys are great. Toby's doing fantastic. But we have we're just trying to make sure at Goal that we're not filing cases that are
we're not stepping on anybody's toes.
Not even stepping on toes, just more hindering each other's ability to
better word
to
way of saying it.
Get this stuff done. We want to be a unified front instead of have a whole bunch of cases that are just kind of crossing
working
over each
together
other.
and everybody hits a certain part of the bill or the law and making sure that our messaging is concise going forward. So
so that's a big part of that's a big part of what we're trying to do. That's really kind of the main thing we're trying to do here at Goal. On top of being, financially involved and being a plaintiff in a number of these cases as well. We're just trying to make sure everyone's kind of heading in the same direction. That's all.
Rather than doing this.
Like I said, we're not the gatekeepers. We're not trying to stop anyone from doing anything. It's just we're just trying. Our objective is to just maximize the available funding and the available efforts
going forward
to get this stuff done.
Because when we work together, the better we are to getting this.
Yeah, I mean, it's the same type of deal if you're looking at, different cases being brought or moving through the process in different states. I mean, if you look at the Maryland case right now, looks like it might be heading to the Supreme Court, which would eliminate the need for us to file an assault weapons ban challenge. And it would solve Illinois' problems and California's problems and New York and New Jersey's issues. So, it's a lot of economies of, not economies of scale, but just making sure we're handling a lot of the stuff economically, I guess, and allocating funds and resources and time where we're going to get the most bang for our buck.
Awesome. So to learn more, you can go to the Goals website, goal.org, and there is a section up top.
Yep.
Do you know the title?
Yeah, I can put the link in there. I don't have it off the top of my head.
I think it's law.
It's
lawsuits.
Yeah, it's
oh, it's right there.
Oh, there we go. It's gold. Oh, hold on. I'm gonna cut this part out. It's goal.org/legal.
There you go. That's what it is.
So check that out.
To donate or become a member, you can also go to goal.org.
Yep.
It's right on the top. And any questions?
Oh, hopefully this...
email us.
Yeah, and hopefully this kind of helped a little bit to understand what cases look like what you're looking at when you're looking at these documents. Like I said, I mean, I'm going to try and sync it up so you can follow along a little bit and see what we have here, but, I'm an amateur.
We're still learning how to edit.
Amateur video editor. So, all right.
Awesome.
Thanks. Once again, I'm Mike Harris, gun owners Action League.
And I'm Kerrie Ann.
Thanks a lot.
Take care.
Bye.